I'll call the ZBA meeting to order. All rise for the pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, roll call.
Gross.
Here.
Milky.
Here.
Warner.
Here.
Tyson.
Here.
Hunter. Here.
Okay. Meeting minutes from October 3rd, 2018. Any comments, questions, or motion?
Make a motion to approve the meeting minutes as presented.
Support.
All right. Tyson motion, Gross support. All those in favor?
Aye.
Opposed? Minutes approved. Correspondence, board reports. Brian?
Just a quick update on the zoning ordinance rewrite. Peter sent out today, wasn't it? Sent out today the diagnostic review that McKenna has done on our zoning ordinance. And I believe through that process, Peter, they met with staff, and is that accurate?
It came out of the kickoff meeting.
It was all from the kickoff meeting and their reading of the ordinance. Okay. So I haven't had a chance to look at it yet, in depth at least. I did browse through it some. I know this was only shared with the Planning Commission, but it seemed like it'd be nice to have the ZBA, even though you're not going to be the ones doing the rewrite, it'd be nice to be able to take your feedback a little bit, because
Sure.
we all have to deal with the ordinance when it's done, right?
Yeah.
Agreed.
So I'll have that conversation with the Planning Commission and see if we can't keep you fairly close in the loop, this board at least.
Okay.
Thank you.
Okay. Approval of agenda. Everybody care to make a motion?
So moved.
Support.
Gross motion, Milky support. Those in favor?
Aye.
Opposed? Agenda approved. Okay, at this time, I'll take public comment of items not on the agenda. If anybody cares to make a comment, and step forward, state your name and address. Hearing none, close the public comment. Okay, down to new business. Appeal 2018-01, Planning Commission, special use 2018-01.
Chair, before we get into this, I'm going to have to recuse myself per ZBA bylaws. I live within 300 feet of the applicant and the property in question. So with your permission, I'm going to step away from this particular item.
Okay, I guess those of us on the board.
What will happen, so we have a member that's disclosed a conflict of interest, 300 feet. There's a, the ZBA member owns or has a financial interest in a neighboring property being within 300 feet of the subject property, qualifies or is listed as a reason of conflict of interest. And so the next step is, before any member may be excused from casting a vote, a majority of the ZBA must find by affirmative vote that a conflict of interest exists. So we'll need a vote from the ZBA, and then Brian will be excused from the vote. Just want to make
So
sure we
just-
get the...
Andy?
I have a question.
Okay.
In this case, in abutting that property, are we able to vote that we think there is a conflict there, or are we just acknowledging the conflict? Because I don't know that.
That would be a question I would have too, is
Neighboring the property in question, to me, doesn't scream conflict of interest, but I don't know if that's open for discussion or if we're just simply acknowledging.
Well, I guess that's what we're.
Well, the conflict of interest, it lists 4 items that are
Okay.
considered conflict
So
of
we're
interest.
just acknowledging Brian's disclosure.
Yes.
So by a majority vote,
Okay.
And I can just call
Thank
a
you.
vote. Okay, with that being said, Paul, do you
So
feel
was-
that he has a conflict of interest?
So do we have to have a motion to do that, though?
No, it's just, it can
Just a
be
vote?
just a vote. It's a conflict of
Okay.
interest as defined.
Okay,
Number
yes.
4 fits it.
Paul is yes.
Acknowledge.
Andy?
Yes.
Jake?
Yes.
And myself, yes.
All right,
Well, Ryan?
Thanks.
Thanks, Brian.
You can come back afterwards. Okay, well, that condition exists, we do have an alternate, so I will ask John if he would come up to the board and fulfill the full board.
Oh, I thought you were leaving. No, I'm gonna do something. Okay, I kept it warm, I got it running for you.
Okay. Okay, all set?
All set?
Okay, with that, now we have a full board. At this time, I will take, public comment on the, special use 2018-01. If anybody cares to make a comment, step forward, state your name and address.
Michael Hackett on behalf of Riverwood. Is this appropriate at this point in time, or is this public comment?
This is the public comment at this time. We will allow you to, state your request
Very good.
after the public.
All right. Yes.
Thank you. Okay, hearing no public comment for the special use, close the public comment.
Well, or Chair, that would be public comment for the items not on the agenda. And then we'll have a public hearing for item 2018-01.
Oh,
Or maybe we already had the public comment of, maybe I missed that.
yeah,
Okay.
we already did. So this was a public comment for the special use. Okay, hearing none, we've closed that. So at this time, maybe, Peter, you wanna give us a little?
Sure. To give the ZBA, we do have a representative on the ZBA from the Planning Commission, but that members had to recuse themselves. So other members may not have as much familiarity with how the Planning Commission works and the whole business of sidewalk waivers, provisional relief, and whatnot. To give you a background, in 2010, the Township developed a sidewalk ordinance in addition to Section 8.325 in the zoning ordinance titled sidewalks. Section 8.325 sidewalks in the zoning ordinance states all new construction or additions requiring site plan review per Section 12 of this ordinance shall provide sidewalks in accordance with the Charter Township of Union Township sidewalk ordinance. And so that is a separate ordinance from the zoning ordinance that guides sidewalk for sidewalks in the township. This Section 8.325 and the sidewalk ordinance are what guides the Planning Commission when dealing with sidewalks in regards to new construction or development per Section 12. Since its beginning, the Planning Commission had made a practice of temporarily waiving, is what we would, the term we would use, sidewalk installation with particular projects. There seemed to be always the same arguments would be made, the same points would be brought up as to why a sidewalk shouldn't be required or doesn't need to be put in at the time. And so the arguments would be fairly narrowly focused, but there was never a particular set of criteria that the Planning Commission would consistently use when applying a decision on whether to waive sidewalk installation or not. We fast forward to earlier this year, and the Township Board adopted a township policy on sidewalks as a guide for the Planning Commission to use. This policy was developed by the Sidewalk and Pathways Prioritization Committee, which gets its duty and charge from the Township Sidewalk Ordinance. It's a committee established by the Planning Commission that then makes recommendations on prioritizing sidewalks and pathways to the Township Board. They developed this policy, recommended it for approval to the Township Board. Township Board adopted it as official policy and then forwarded it to the Planning Commission to use as a guide in helping them establish a set of criteria that they hadn't in the past used before. In your packet was a copy of that policy, and as you note in the policy, there are criteria, but it is not criteria that is a shall, it is a may. And so when the Planning Commission goes over these site plans, now with this new policy, they take all of these factors into consideration, but whether one or all of these factors are present, it is still a may and not a shall on whether the Planning Commission gives provisional relief. And the key there is also provisional relief. The Planning Commission, when they give provisional relief, it is not like for this body when we grant a variance, it is not saying that sidewalks, you never have to put them in. It is simply just stating that you don't have to put them in at this time. I guess a common phrase is you're kicking the can down the road. Instead of putting them in with this new construction, you will be required to put them in later when the township deems it necessary. And so just keep that in mind, that when the township weighs on whether a project should be given provisional relief from construction of sidewalks, it is not a permanent relief from ever having to put sidewalks in. It is simply just, lack of a better word, kicking the can down the road. And so that is a background of how the township operates the Planning Commission and sidewalks. The appeal that you will be focusing on, this body, as in state law, has the right to review and determine any Planning Commission decisions. And so when we're doing this appeal, you want to keep in mind the policies, the ordinances, the procedure that the Planning Commission used, and not that if you were on the Planning Commission, you may have voted differently, but did they follow the procedures? Did they follow the ordinance? The decision that they may have came up with may be different from yours, but we're not here to cast judgment on the Planning Commission's judgment. Remember, in their policy, the criteria did not say that if it met X, Y, and Z that they would have to grant relief. It is that they may grant relief. And so that is the first part of tonight, is in the appeal on if the process was followed, if the ordinance was applied and followed, and find if there was any error in this determination made by the Planning Commission. Post that, the second part of tonight, which I've put in your memo, is on deciding if any kind of relief from the ordinance should be granted to the applicant. Same way we grant variances from other requirements in the zoning ordinance, we would be applying the same criteria on whether the applicant would qualify for any variance from particularly section 8.325 sidewalks that states all new construction or additions requiring site plan review per section 12 of this ordinance shall provide sidewalks in accordance with the Charter Township of Union sidewalk ordinance. So that is the variance from which you would be determining. So I'm here for any questions you have. You have a very lengthy packet of information, and so there's a lot to digest. But I'll digress to the chair until you guys need any further assistance or questions.
Okay, well, I think at this time, we'll let the applicant and a representative just come up if they care to make comment.
Thank you. All right, good evening. My name is Michael Hackett, and I'm here on behalf of Riverwood Recreation Incorporated, or the Riverwood Golf Club, asking for provisional relief from this requirement of placing a sidewalk. Sometimes I feel like I should apologize for giving somebody a lengthy packet. However, I didn't want to leave out important information, and quite frankly, I want to make a record here of what our request is, and with that record, I needed to be able to give you diagrams, some layout of the area, have you totally understand this setting so that you can make an informed decision. I actually brought a Google map photo, and I'm just going to set it here, but we're talking about Riverwood Resort. And Riverwood Resort is the golf course, and that golf course extends to the north of this photo. Broomfield Road runs along the south edge. There's Whitehead Farm is on the other side of the road, and Whiteville Road turns and extends south here. The setting is this. In 2017, we suffered a fire and it burned down a maintenance pole barn that had been there for years. The pole barn was over here on what we call the edge of the blue course. The blue course is to the west, and it's this pink colored arrow. Determination was made that we needed to build another pole barn. We built the other pole barn, the replacement barn, over on the very east side. It's 680 feet off the road, and as a part of the Planning Commission materials. Oh, good, thanks, Mark. As a part of the Planning Commission activity, we were given permission to put in a drive that extends directly off to Broomfield Road. And again, this is 680 feet back. I suggest to you that that's relevant because the requirement that the township is asserting is that Riverwood build a sidewalk for a half a mile along Broomfield Road, the entire distance of the frontage of the golf course. And so that's not the area around our pole barn and maintenance shed. It's all the way across the road. And that includes the area in front of the bowling center. There's a pond right here, it doesn't show up real good in the Google photo, but the fact is that that pond extends up relatively close to the road right-of-way. And it's going to cause a problem if we have to build the sidewalk. In addition, there are trees and other growth along the road. We actually counted them, and there's 27 trees. Several of them, a number of them, are old walnuts, and they are right along the fairway for what is number 5 on the blue course. The sidewalk ordinance provides that the sidewalk has to be built 1 foot in the road right-of-way. And this road right-of-way, 33 feet from the center of the road, then extends onto the fairway at an edge, there's a ditch along that road. If one went out and looked at the proposed or required place that the sidewalk has to go in the ditch, over the trees, through the trees. Now, several of these trees are 24-inch to 30-inch trees. They'd have to be taken out. Otherwise, this required sidewalk would have to go up on the road shoulder. And in that situation, I would suggest that that's dangerous. Now, I'm going to touch on a number of these issues as we move through this, but the fact is that we're of the opinion, and we propose to you, first of all, we propose to the Planning Commission that this placement of the sidewalk is unnecessary and inappropriate. And at this point, we are asking for relief. Now, it's a provisional relief, and that provisional relief is such that we're asking that we not be required to put the sidewalk in now. At a point in time, if this area is totally developed into a residential area, there may be a reconsideration by the township, but at this time we're asking that the sidewalk not be required. I attached to the material as Exhibit 3 the recommendation from the Sidewalk and Pathways Prioritization Committee. And this material I suggest is important because it sets forth from the Prioritization Committee the set of rules for a provisional relief. The Prioritization Committee did an analysis, and Peter explained quite appropriately how the Prioritization Committee came about, what it was there for, and what they did. Well, they too needed to make an analysis of whether or not sidewalks are going to be required everywhere in the township, including rural areas like this. And the Prioritization Committee then came up with first an area that they would recommend that sidewalks be installed, and then an area where the sidewalks not necessarily be required. The area that they were recommending that sidewalks be installed, I guess put differently, Riverwood is not in the area where the sidewalks are recommended that they be installed at this time. And primary reasons include their criteria for granting relief. One of those issues has to do with whether or not there's any sidewalk in the area. There's no sidewalk within a mile of Riverwood Golf Course. If you head east on Broomfield Road, back toward town, the first sidewalk is at the First Community Church, which happens to be in the city of Mount Pleasant. If you head north, when you get north, you have to go to Lincoln Road, half a mile, and then you go north, and there's a sidewalk that was constructed as a part of the McGirt development at this point in time. But there's no sidewalk on Lincoln Road. If you head west, there's a subdivision and there's no sidewalk in that Stone Ridge, I believe it's called Stone Cliff, Stone Ridge subdivision. If you head south, that's Whiteville Road, there's no sidewalk there. And as you head down on Whiteville Road, it's very, very rural, specifically the Billy Whitehead's farm and then other farm activities. So to question whether or not it's appropriate to require the Riverwood Golf Club to put a sidewalk in, it's quite clear that when looking at the criteria from the Prioritization Committee, they were saying this doesn't fit the neighborhood. Another of the criteria that they used was less than 50% of the surveyed sections of the township along the road fronting the proposed development has sidewalk. Oh, I'm sorry, I just touched on that. Another of the areas had to do with an evaluation of car pedestrian accidents and whether or not there had been any car pedestrian accidents in the past year. I supplied to you what we got from a Freedom of Information Act request, first of the state police and secondly of the Isabel County Sheriff's Department. And again, I didn't mean to kill a tree with all this paper, but the fact is that I wanted to be complete in showing you that there were no car pedestrian accidents. Most of the accidents out there were car deer accidents. There was one head-on some years ago, and a number of the other accidents had to do with rear-enders up at Lincoln Road. So when I look at that item for purposes of this criteria, it doesn't fit. We're not in this situation in a setting where you would be looking to build a sidewalk in order to prevent car pedestrian accidents. The next item in the criteria has to do with the cost of the sidewalk construction exceeding more than 50% of the cost of the project. I supplied to you an estimate of the cost of this sidewalk, $245,000. The pole barn is a really nice barn, $300,000, but the fact is that when you use the criteria set forth by the prioritization committee, the cost of the sidewalk exceeds more than 50% of the cost of the barn. Candidly, I would suggest that that bid from Isabella Corporation is low because it doesn't include building around the pond. It doesn't include building up the ditch, and it doesn't include taking considerations of the utilities that are buried underground. When utilizing the prioritization committee criteria, I suggest that we're simply in a situation where it doesn't make any sense to build or to require the sidewalk in this setting. Part of the discussion that we had with the Planning Commission included an issue of safety. Specifically, the township appears to be requiring that we build a sidewalk along the left-hand side of a golf course hole. And I don't know how many, if any of you folks have played that golf course. I will tell you that I started playing out there when I was 12. That was 1960. And I've hit more balls across that road than you can imagine. Well, the fact is that what the township is requiring here is that one build a sidewalk on the side of the fairway that would place people in harm's way anytime somebody is teeing off or playing that hole. At this point in time, again, I'm offering to you a number of considerations that would suggest that it simply is not reasonable to require the sidewalk in this rural area and on the golf course. Now, I recognize that you have an issue with in front of you that has to do with identification of activities of the sidewalks and prioritization committee. I spoke with Jeremy McDonald, who was head of that committee, and he indicated to me that he felt that it was important to pass on to you some of the thoughts of the committee. And so he sent me a letter that I received yesterday, and I'd like to share this with you if I could.
Okay, sure, if you got copy, you can pass out, or
I'm sorry?
if you got copies, you can pass them
Thank
out.
I do. There you go.
Thank you.
Okay. Here.
Thank you.
Thank you.
I'm always hesitant
Okay.
to begin speaking when somebody's reading, so hopefully we've had a chance to get through this. Interestingly, Mr. McDonald noted the very same point that Peter offered in his explanation early on, and that is that the prioritization committee included in their recommendations the term may consider this for provisional relief, as opposed to shall consider this for provisional relief. I believe that you, as the zoning commission, zoning board of appeals, have the absolute right to make a determination that it is fair and reasonable that the golf course not be required to put in a half mile's worth of sidewalk. I would suggest that that's the conclusion made by the prioritization committee, and they weren't intending to pave the whole township, and this is probably the best example of placing a sidewalk in an area that is not suited for it, number one, where it's not necessary, or it doesn't really have a purpose. The golf course has been there since 1933. It's been owned and operated by the Fig family since 1960. And because they had to put in a storage building, the requirement got implemented so that it's now being suggested that we would have to build a $250,000 sidewalk that doesn't really have a purpose. So with that, we are requesting that you make a determination to grant the provisional relief that we sought, and that you use your authority as the Zoning Board of Appeals to make that determination, and you do have that authority. I'm happy to answer questions. I hope that I touched on issues that were there and relevant. Anybody have questions for us?
Well, I guess at this time I'll take it to the board, Mike, if we do have questions.
We're here,
we'll
and
ask
I'm
you.
more than happy to
Okay.
cooperate or to take part. Yeah.
Okay.
Okay.
All right, thank you. Okay, board members? Any thoughts, comments? I guess kind of the first item on our list is whether the planning commission did follow policy in their review of the site plan. One of our objectives, first off, I guess, we can look at that.
As I had said before, in section 8.325, I can kind of guide you guys through our ordinance and step by step. 8.325 sidewalks in the zoning ordinance. All new construction or additions requiring site plan review, so keep that in mind, requiring site plan review, per section 12 of this ordinance shall provide sidewalks in accordance with the Charter Township of Union sidewalk ordinance. So let's look at section 12 in the site plan review. Section 12 of the zoning ordinance. Okay, so keeping a finger on 8.325 as we look at site plan review per section 12, all new construction or additions. In section 12, the first one, 12.1A, all special land uses. So if it's a special land use, it requires site plan review, and if it requires site plan review per section 12, all new construction or additions shall provide sidewalks in accordance with the Charter Township Union Sidewalk Ordinance. The property is zoned R1, rural residential. The golf course is a special use in section 14, 14.2 F1, country clubs and golf courses. So it is determined that the use is a special use country club golf course permitted as a special use in an R1 rural residential district. All special land uses are requiring site plan per section 12 site plan review. And so then in accordance with section 8.325 sidewalks, all new construction or additions shall provide sidewalks in accordance with the Charter Township Union Sidewalk Ordinance. We do have, so then we look at, did we have new construction? Yes, we had new construction. This was a new building in accordance with Charter Township of Union Sidewalk Ordinance. We have that ordinance. The last sentence in sidewalk states the Planning Commission shall have the power to amend or waive the standards of the Union Township Sidewalk Ordinance. Now in our own township sidewalk ordinance, it doesn't specifically state that the township has the authority or has had the authority. You could have your own interpretation that only by past practice has the Planning Commission had the ability to even temporarily waive these sidewalks, but it has been the past practice since the implementation of this ordinance. What it is explicit on is that they do have the ability to waive the standards. Standards in Section 4 of the Township Sidewalk Ordinance talks about construction standards, use of sidewalks, pathways, maintenance standards, and that's it. Those things, those items, the Township Planning Commission does have explicit ability to waive and amend. The Township Planning Commission has in the past been able to work with applicants due to maybe grading issues or location of trees, utility lines, been able to amend the standards of the placement, the width of the sidewalks, in order to best accommodate for the placement of those sidewalks, so that if there's any kind of hurdles that the developer faces in putting a sidewalk meeting the standards that are set forth in the sidewalk ordinance, the Planning Commission is able to work with them and find a better location so that sidewalk development can still take place. And so that is how we got to where the discussion of even sidewalks began. And so I guess if there's any, now in regards to the policy, the sidewalk policy that was developed by the Sidewalk and Pathways Prioritization Committee, adopted by the Township Board as policy, and then forwarded to the Planning Commission as an official guide when determining sidewalks. The Planning Commission did have that document. They went over criteria. They brought up issues of safety, sidewalks in the area. Ultimately, they decided to not waive sidewalks, to not grant provisional relief from the construction of sidewalks. And that was their judgment call. And so going through the steps, the first thing this board would want to answer is, was the correct process followed?
Okay,
Yeah.
thank you, Peter. Andy?
So, considering that we're looking at two separate items here, I think it's pretty clear to me. While the Planning Commission meeting was difficult to follow at times and a little bit, I shouldn't say out of order, it got caught up a little bit because they were lacking members from recusal, so they were tied and they had to revote. If you look at that, it became a little bit convoluted, but in the end, I do believe they followed policy. I think they followed the procedures that they have in place. They arrived at their decision in keeping with the ordinance and the requirements. So that part of it, at least for me, seems fairly simple. I don't know if anybody else has any thoughts on that.
Question for you, Peter. Level 3 of the Michigan Rehab Code for existing buildings. Okay, we burnt one down, we rebuilt another one on the same lot. Where it's at probably doesn't make too much difference. But that building that we rebuilt, what percentage of that, of the whole golf course, building, structure, all the rest of that, would have to be 25%, 50% of it, 10% of it?
You're asking the when you take all the buildings together, what percentage was the accessory building?
Yeah.
I don't have an answer for that.
Would 25% or 10% be somewhere in it, just looking
I'd
at
I'd have to defer to the applicant. I don't even want to make an assumption.
I believe that the golf course is actually about 300 acres. It extends on the opposite side of the river, and it runs for a half a mile along Brewfield Road.
I'm just talking about construction cost of the existing buildings and
Oh, okay.
fairways and all the rest.
I thought you were asking what percentage of the acreage
No,
was
no.
being used for this building, and it's minimal.
Minimal, yeah.
The cost of construction of the building was approximately $300,000.
So the rest of it might be worth $1.5 million or $3 million.
Comparing it to the value of the whole property and the value that it costs to build the building, I think is what John is trying to.
Oh.
I'm saying, if it were part of the main structure and it burnt down, would it fall into the category of 10% of it was
25% rebate over
Yeah.
50%.
I would suggest that it probably is 5%. This is a bowling alley, restaurant, lounge, accessory buildings. These are condominiums. This is the pro shop and central area. And there are other accessory buildings over here that
Okay.
were the old clubhouse back in the 50s and 60s.
Okay.
So
Where
it's
where
very
I'm
minimal.
coming from is, if this had been attached to the main building or something like that, and it burnt down and you were gonna rebuild it, it may not have fit in the category of the level 3 of Michigan Rehabilitation Code that would have to require a site plan revision. Just something to think about.
That's
Well,
correct.
but in your example, as you said, if it was attached, but in this case, it wasn't attached.
No, it's still a detached building, but
yeah.
it's still part of the whole project. That's where I'm coming from. And it's 680 foot from this proposed sidewalk.
Okay,
Are we gonna try and make a motion on the procedure being followed adequately and then separately make a determination?
yeah, I think
The balance.
Two separate.
yeah,
Okay.
that's.
Two separate,
I guess the outline will determine if first the planning commission followed the ordinance.
Okay.
And then we'll look at the appeal for the sidewalk.
Okay.
Granting
So-
relief of the sidewalk.
Right, relief of the sidewalk.
I guess
So
regarding
at this time,
the first point that Mr. Tyson addressed, I would concur with his comments, reading through the materials, that the proper procedures were followed, at least in my opinion.
I went through the steps.
If they were following the criteria, it
Yeah.
comes to the end and it says they may, that they shall, so they can do anything.
Correct.
Right. So as far as reviewing the site plan, and then they follow procedure, follow the ordinance as a guideline. With that, I guess, we'll take it, take a motion. Peter?
I would make a motion that it appears that the planning commission has in fact followed the township ordinance policies and all applicable township ordinances associated with special use application 2018-01.
Was there support for it?
Support.
Jag support? Any comments? Those in favor?
Aye.
Aye.
Those opposed? Hearing none? Motion pass and review. Okay, now, the second part of that would be their request for a waiver.
Well,
at
in-
this time.
and the thing that I would suggest, or well, I don't want to suggest.
I shouldn't use that word.
Because the only authority that that we can give relief from is the zoning ordinance. We can't give a variance from any separate regular ordinance such as the township sidewalk ordinance, or we have a message center sign ordinance. Those regular ordinances, stormwater management ordinance, we don't have the authority to grant a variance or any kind of relief. We can only grant a relief or a variance from what is in the zoning ordinance. Likewise, the township policy that was adopted by the township board, that is not in our arena to grant a variance
Part of our
from.
our review, okay.
And so what you want to look at is what is in our zoning ordinance, 8.325, and that's sidewalks. And I've read the sentence a few times. All new construction or additions requiring site plan review per section 12 of this ordinance shall provide sidewalks in accordance with Charter Township of Union sidewalk ordinance. And so we've all been determined and in the motion that is required, that the applicant followed that requirement. And so you are to look at going through section 5, 5.8, 1, A through E, or excuse me, 5.8C, 1, A through E. The criteria of whether a variance should be granted. This would be the first application that we've had in my time here, and I don't believe there's been before a variance request from sidewalks from the ZBA since the implementation of the sidewalk ordinance, when the issue of sidewalk waivers and relief began. The issue has always remained at the Planning Commission level, but we do have the authority to look at that section and decide on whether a variance from that requirement of sidewalks could be given. So I would take the board to, if you have a copy of the zoning ordinance with you, that you brought with you, to section 5.8 C1 A through E. Also in your memo that I provided for you, I went through the criteria, and so even if you forgot to bring your book with you, in the memo, you can look at the criteria that we went over. The first one is, well, or let me read variances, conditions, governing applications. Procedures to authorize upon appeal in specific cases such variance from the terms of this ordinance as will not be contrary to the public interest where, owing to special conditions, a literal enforcement of the provisions of this ordinance will result in an unnecessary hardship. A variance from the terms of this ordinance shall not be granted by the Board of Appeals unless and until a written application for a variance is submitted demonstrating, and here's the first one, A, that special conditions and circumstances exist that are peculiar to the land, structure, or building involved that are not applicable to other lands, structures, or buildings in the same zoning district. So keep in mind, the district is an R1 district. That's the district we're looking at. And we're looking for conditions and circumstances that either exist that are peculiar to the land, the structure involved, or building involved that are not applicable to other lands, structures, or buildings in an R1 same zoning district. When I went through it, we have, it's a large parcel, R1 parcels. They have a requirement in size, but they are not all uniform. They have a minimum size that you have to meet. Other R1 parcels are larger than others, as long as they all meet the same requirement. This parcel does meet the minimum requirement in width, square footage, so there's nothing peculiar about the actual parcel of land itself. The structure, it's an accessory building associated with special use. Accessory buildings are not uncommon to be found on R1 property for a permitted use or even a special use. And so I didn't find any conditions or circumstances that were specifically peculiar to the land, structure, or building involved that I couldn't find applicable to other land, structures, or buildings in other R1 districts. But for you guys to digest, debate, and if you have any other comments.
So I mean, at this time, the variance request, or it's basically a variance request based on 5.8 C1 is our criteria to follow. That, I guess, is, don't be confused with any other.
Yeah, that's the criteria that we'll be looking at.
So with that, did you have a comment, Andy?
Yeah, I mean, in my review of this application, as I do with all of them, I went through the criteria and looked to see, just as Peter's started to outline, line by line, what my interpretation of those particular items would result in. And right off the bat, I'm struck with the fact that this building caught fire. That's a pretty peculiar and unusual circumstance. I don't believe that Riverwood Golf Course intended to redevelop this pole barn had it not been for the fire. And so I don't want to speculate on that, but that immediately jumped out at me as a condition or circumstance that is peculiar to this particular project. while the building is still a building and the site is still the site, and the uses and all of the technical criteria are in fact true, I don't think we'd be having this conversation about whether or not the building needs a sidewalk if it hadn't burned down. So that jumps out at me. And then as we continue to go down the list, I'm struggling to really see why it would be something that we wouldn't be considering. So I can continue to go down and throw my 2 cents in. I don't know if anybody else has concerns about that. I don't want to monopolize the floor.
No,
I think it falls under special conditions and circumstances to that peculiar land. It's next to a golf course against 2 holes. We want to put a sidewalk behind having somebody hit in the head walking down a sidewalk.
one of the other concerns.
That's one of my concerns about putting a sidewalk there.
Mhm.
And if they move the sidewalk to be less costly inside of those trees, the situation gets even worse.
Sure. Yeah, I mean, continuing down the list, if that's all right with you, Tim.
Yes, go ahead.
C1A, B, the literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same zoning district under the terms of this ordinance. I don't believe that's the case, because of the policies. Although we're not making a determination about those policies, everyone that's in those districts is still subject to pursuing provisional relief. Therefore, I don't think that this is depriving the applicant. And then to play off of that one, you're going to go down. I'm going to skip C and D real quick and jump to E. No non-conforming use of neighboring land, structures, or buildings in the same zoning district or permitted use of lands, structures, or buildings in other zoning districts shall be considered grounds for the issuance of this variance. We're not, that's the precedence argument, right? We would talk about that all the time.
Right.
Again, going back to this being a unique situation. And then jumping back, if you can keep following my track here, the special conditions in C, the special conditions and circumstances don't result from the actions of the applicant. They didn't build the golf course knowing that this all had to happen and then didn't do it. I mean, that didn't come out in the wrong order or something, that they didn't intend to rebuild the building. It caught fire. It's certainly not their fault. And then we're not giving special privileges to them that is denied to other people because they have the ability to seek that same provisional relief. So unfortunately at this point we'd be offering a variance because it has already gone down the road of the Planning Commission. So on that, rather than me continuing my argument, that leads me to one question, and then I promise I'll stop. Since we'd be considering it a variance, it's no longer provisional relief. We grant the variance and the sidewalk's never going to be there. So I mean, it's a long-term, this is the final determination here. So that, having watched that meeting and seeing how hotly contested it was and all the options and ideas and thoughts, I'm a little bit conflicted about that piece. But when you look at the arguments the way they lay out, I think it's fairly self-explanatory to me, based on the special conditions of it being a fire. But that's what I've got so far.
Could we put constraints on on this if we decide to put a variance in to say that, you know, it would be reopened if deemed necessary by another board? It's down the line. I know that probably creates some wormholes.
You are allowed to as this board has done before in the past, with any variance granted, you are allowed to set conditions on that variance. I would suggest if there's any conditions that you were to place on the variance, that they would be concrete, that you wouldn't leave them to the interpretation of another board. An example would be that you know, a variance would be granted on sidewalk for this project, but it would not apply possibly to future development, any other new construction. You know, that it would only be for
This building.
the accessory building in question.
So some other
Because
activity on the property.
Because otherwise, you know, if you put a condition that until the township board deems necessary, it's, you know, that policy
makes
can always
sense.
change.
Yeah, that makes sense.
And I acknowledge that a condition of variance is a well-respected or recognized zoning concept. So it can be done.
Okay. Andy?
Could that condition just be that the variance is granted under the condition of following the provisional relief criteria that would have been in effect? Are we allowed to piggyback on that and just suggest that the provisional relief criteria would be our condition?
Could we just leave it the way we've done before and leave it to the Board of Trustees to call it in if we give one?
Well, and I'm glad you bring that up, because I would be curious to hear how that would come into play.
Well, let me just go over that before you get too far down. If you look at the township sidewalk policy, if you talk about piggybacking on, okay, so the Section 3, Sidewalk and Pathways Prioritization Committee recommends to the Township Board property owners previously granted relief waivers to construct sidewalks that have road frontage along the developed or along the designated streets as identified by the committee on March 12, 2018 need to be contacted and plan developed for sidewalk to be constructed within 2 years. This property doesn't apply to that. This property did not fall under the designated streets, so you take that out of consideration. Number 2.
But that can be changed.
Well, that's what he's.
And that's where I would suggest that if any conditions are made, that you make the conditions in your own writing, in your own words, so that you don't leave it for something that can be changed later.
That makes sense.
Number 2, the designated streets accompanying map and criteria for granting relief should be reviewed yearly by the Sidewalk and Pathways Prioritization Committee and adjusted as conditions and growth occur within the township. And so if you were to just say until the township deems necessary, know that the township could deem it necessary in 6 months. There is no timeline.
Next week or whatever.
And so if you were to be looking to grant a variance on the condition that, well, when the township deems it necessary, know that, you don't know how long you're actually giving any kind of relief. If you were to, and that's where I'd suggest if you do find a supporting reason to grant a variance, that if you want to place a condition on it, place a condition such as your own criteria of construction, that would automatically trigger then.
Gotcha.
Specific limits or.
Yeah.
Thanks.
I was the only one that talked. Anybody else have any thoughts about that? I mean,
Comments?
I think that what we've done before would be adequate. If the township wants to call them in, they can do that. They can call that on any parcel and say, we want townships, that they want to pass ordinance and not fund it and so on. It's no different than an industrial. We've had people come in for the tank farm over here, or that tank manufacturer. They got an industrial back there. We gave them a variance there. It was callable by the township. Same thing with the merchandise outlet. Now we have called that one.
You're not talking about variance, you're talking about when the, for sidewalks.
For sidewalks.
Okay, yeah.
Just
Yeah,
relief.
Yeah, and that was with the planning commission.
At the planning commission
Yeah,
level.
okay.
And all we're doing is,
But they must come in with something by then.
Yeah, no, and so the, what you're saying is correct, but I just don't want you to get, this body hasn't dealt with sidewalks before, the zoning board of appeals. And so each individual applicant, when they come to the site plan, they make an argument on whether, they're okay with putting in the sidewalks. If they have a problem, or a conflict, they list the conflict and put it in the sidewalks, and then the, planning commission would, they would weigh on whether to relief or not. And it wasn't until this year that a policy was developed to actually give them criteria. Before it was, you know, as I said before, a lot of the same points would be brought up, but there wasn't a uniform criteria that they'd go over.
Yeah, but it doesn't say shall, it says may.
Mm-hmm.
That's the planning commission though.
Yeah, for the planning commission.
So with the ZBA and the requests for a variance for a sidewalk or not on this parcel in question is what we're here to review.
We're granting a waiver.
You're not granting
No,
a waiver. You,
we're granting the
you would be granting a variance from.
Variance.
Now, another thing to keep in mind is the in variances, for example, we could have a request in the past, say they weren't able to meet a setback requirement. They wanted to get 10 feet of relief. You know, this body has the ability to say, we don't think you need 10 feet, but we'll give you 5 feet of relief. And so another thing to consider when granting a variance on the sidewalk is whether you would grant a complete variance of you find a reason, A through E, that a variance from a sidewalk completely on the property, or if you would only give it partially on the property and also with any conditions. But before you get down to that level of conditions and whether you want to give a full variance or not, you want to narrow down exactly A through E where the hardship, the special condition, circumstance exists. You want to narrow that down before you guys get further in making the motion.
When I first looked at it, what jumped out at me was C, is special conditions that were as a result of actions of the applicant. It was a fire, as you commented. It was a fire. It wasn't anything that they did.
Right.
And it resulted in having to rebuild that building and fall into the site plan review. So that would be a condition that I would.
Not the fault of the
Yes, not, yeah.
applicant.
And so when that point's brought up, the idea is if there was no fire and the applicant wanted to build a new building, that would not be seen then as a special condition, that then it's.
That
But
would
that's-
be my interpretation. The
be
fire, the
applicable to
fire
everybody,
is
yeah.
what it was the
Yeah.
triggering event
That's,
for
we're-
this.
Yeah, that's another thing.
Yeah.
Because when I did mine, I did take the fire into consideration. The way I looked at it is and although the applicant didn't originally own the property, it is a special use, and so any kind of construction, as we went through, involved with a special use, is going to require site plan approval. And so the applicant is aware of that, and it came to very unfortunate circumstances, and what resulted them in having to construct. But for me, I looked at it as it's an existing special use. Special use is any kind of new construction requires site plan review. So the idea of I have to build, now I have to do site plan review. Site plan review requires sidewalks. It's not like a surprise of something that wasn't established already this decade.
I certainly see your interpretation. I mean, it makes sense. I just keep going back to, I mean, if you look back at the prefix in C, there's a comment in there about a literal enforcement of the provisions of this ordinance would result in an unnecessary hardship. They're already spending money on the building to rebuild it due to the fire. So that's kind of where my train of thought went. So if I'm out of line on that, I'd like to hear a competing argument.
The only thing I would add is when we talk about unnecessary hardships, our ordinance doesn't qualify any kind of monetary. So
Sure.
it's all in the back of our mind. We realize it, we understand it, but we can't use that as an excuse for the unnecessary hardship.
Okay.
I really don't have a counter argument to the points that have been brought up so far by Andy and Paul both. I'm kind of right in line with what you guys are seeing and thinking on this property. I'm having a hard time flipping and giving another opposing view to that currently for me.
If there is no other comments, anybody have a motion? One
So before
side.
we go to the motion, should we list the specific responses to our A3 criteria to get those on the record? I mean, I ran through them very quickly, or if that's unnecessary, if we're all in agreement.
The
Well,
only
I
thing,
think
the only
we can
thing,
do it in the motion. Can you?
well, the only thing you want to put in the motion is indicate the actual reasoning. And I heard the C, special conditions circumstances do not result from the actions of the applicant. And so you can list C, recognize that the existing building was destroyed in a fire. This is what caused the construction of a new building. And so you just want to indicate the one that you did find as a reason, because when you do grant a variance, if you grant a variance, or if you don't, you have to, list the reason why or reasons.
So we can talk about individuals first before the motion?
Under that theory, in my opinion, the special conditions in A, special conditions and circumstances exist that are peculiar to the land structure or building involved and that are not applicable to other land structures or buildings in the same district. I think the fire is that same argument in this case because it is the special conditions. And then in C, we're acknowledging that those special conditions did not result from the actions of the applicant. So then B, the literal interpretation of the provisions of this ordinance would deprive the applicant of rights commonly enjoyed by other properties in the same district under terms of this ordinance. So, my interpretation of that would be that other people, anyone in an R1 district, would have the ability to seek provisional relief. And I don't know, because we're not determining provisional relief here, we're determining a variance. I think that's still indicating the rationale, because everyone's eligible for provisional relief. In this case, offering a variance is that's the authority that we have as this board. So to me, that's the argument for B. We've touched on C. Then we move to D. The granting the variance requested will not confer on the applicant special privilege that is denied by this ordinance to other land structures or buildings. And I don't think that's the case, because this is a unique circumstance and we're treating it as such, which clearly rolls into E, that no non-conforming use of neighboring land structures or buildings. We're not basing our decision on someone else's previous variance request. So in my opinion, I think that outlines it pretty clearly, but I still would like to be very specific about the criteria and under which, or the conditions under which we grant it. Then it's a no-brainer that it should be project specific to me. Has to be related to simply the building of this accessory building.
Correct. And any other construction would trigger.
They'd be back
The
to square
normal
one,
back, yeah.
back to
Yeah.
the criteria in the ordinance.
Absolutely.
I think we need to mention that it's a hazard kind of in that particular site of golf balls hitting people.
Okay, I'm gonna back up a step, because it was hotly contested by the planning commission. There was thoughts of the west side being included and the east side being included, and then skipping the pond. And I would see no issue with the variance indicating now and forever that pond did not have to be redeveloped to have a sidewalk. That, to me, it would be something I would look as a possible criteria, because it would be simple enough. In the event of future development, a sidewalk was required, and it had to go in from the easterly property line up to the existing east drive. Any pedestrians and bicyclists could use that existing parking area to get around that pond and then pick back up on the other side. But that's not in our purview how they get to that point. But I would be willing to consider restricting the pond with a permanent variance. And then the duration, I feel like we should set a duration for this, or the triggering event. To me, instead of the duration, it would be they have provisionary relief, or we have this variance, which is good up and until they pursue another project that triggers site plan review and the sidewalk requirement. I don't know,
Yeah, that's amenable to me, for sure.
Yeah.
is that clear and concise enough, Peter?
Well, if I'm getting all your thoughts,
I'm all over the place.
what you're talking about,
I've got quite a lot of notes though.
so it would be for granting a variance. The reason for the granting of the variance is it's not peculiar to the land but the structure.
Correct.
This structure was destroyed in a fire.
Not caused by the applicant.
Okay. And it was determined that the fire was not caused by the applicant. Okay, and so, the peculiar A, special, the condition, circumstance, was not the action of the applicant, so that's A and C. And so you are looking at a variance, for the sidewalk on the entirety of the property?
The way that I would word that, and somebody stop me if I'm not trying to pigeonhole us here. I'm thinking that we would grant a permanent variance for the sidewalk between the two existing driveways. So over the area of the pond. To me, that should be a permanent variance. It's existing, don't disturb it. So in my mind, we need to clarify that the pond would be,
Two parts to this.
yeah, the pond would be a permanent variance, and then from property line to each existing drive would be a
Triggering event.
a temporary variance based on a duration of,
Just for that, this particular.
for this
building.
project, but based on the duration of the next triggering event that would require site plan approval.
And so what you're saying
Up to
is,
that point.
so here's the pond. We have an entrance, an easterly entrance and a westerly entrance, ingress, egress, ingress, egress. And so what you're saying is you're looking for a variance west and east of these two entrances and exits, which would then be only applicable to the new accessory building and not any other new future construction
Correct.
of buildings.
That would require.
That would
the site
require
plan.
the
So
site
the-
plan review.
So the duration is not a date certain, but rather based on the triggering event of a new
A
site
new
plan.
new construction, that would okay. But between the two entrances, you're looking at a permanent variance to where no sidewalk, regardless of new development, would go in.
That's one of my thoughts.
So I
I'm
got a
just-
question about
Okay.
that, and maybe it's a question to the landowner, the representative, because all of a sudden we're putting public traffic into private property by doing that. You're either gonna push them out
Sure.
on the road, or you're gonna push them
It's a valid
through
point.
through the parking lot. Because the sidewalk will be on right away, road right away,
Mhm.
correct?
Well, and
Yeah,
that's where I wanna get
yeah.
with the planning commission, where it is explicit that they have the ability to waive and amend, is the standards of the sidewalk construction. And so if there is a, if there's not room to put the sidewalk here, you can't put the sidewalk through the pond. If a plan was made to where it would wrap around the pond, be far enough safely away from the road, or some kind of unique design, the planning commission does have the authority to amend the standards so that the standards in the sidewalk ordinance are not prohibiting sidewalk development.
You know, you could relocate that, and I don't know how much fill it would take to fill in that pond to get a sidewalk in there.
With the stormwater ordinance, you don't even wanna go down that road.
See,
Well,
and
that's without knowing that whole
See,
situation.
I wouldn't wanna mess with the pond. I agree with you there,
Well-
but how we
The next question I'm gonna ask now is, and John brought it up, is the safety factor. I mean, it's been demonstrated, repeatedly brought up by the applicant, there's a serious safety concern. I'm taking the applicant at their word, they own and operate the golf course, they would have a better understanding of the safety concern along, number 6 there, or 5. Five. There's concern there too. I mean, I don't love the idea of a sidewalk going through there and somebody's riding their bike and they get conked on the head because I rip one off to the left. I mean, that's a very real possibility. So,
there's a possibility of putting nuts too.
Yeah, I think that would, I think, you know, with the pond, that's a specific set there for several different reasons of just viability of running a sidewalk with that pond there. The screening and future use, if they need to put sidewalk in alongside the golf course, it's not unheard of to see city sidewalks go by golf courses. You know, I've seen it quite a few times. It's just either, you know, tree screening or other screenings, but that, you know, for me, the pond would be the where I would draw the line in our conditions, to protect. And maybe even write something in there about having it on the Broomfield front side of that pond be permanently exempt. And then, you know, that would give them the ability to wrap it around the back if they needed to at some point too, you know.
Well, and so if I'm listening correctly, because my concern is if a future development occurs, we go through site plan review, sidewalks are required. So we place a sidewalk, stops, place a sidewalk, and you have a gap. Are you leaving enough or an option to where this sidewalk would be somehow continued, or I mean, the person would just stop and they wouldn't be able to continue?
See, that's kind of my
Well,
question.
maybe
Is
put
what
within the road right away or anything?
well, within the road right away, or as you mentioned, Peter, the planning commission does have the ability to regulate on the location and construction method.
Yeah.
More technically speaking. So
Yeah.
I think, to Jake's point, we're saying no sidewalk, or variance for a sidewalk be granted from the south edge of the pond to the right of way, to the roadway.
That no variance would be granted?
No, that a variance be granted, like
Permanent.
permanent variance.
Permanent.
Permanent
Meaning
variance.
that no one would be required to build a sidewalk in between those two driveways, located south of the pond and north of Broomfield Road.
But it would be limited to the right-of-way to the pond, and so it would leave room for a sidewalk to maybe be looped around?
Correct.
Yeah.
Yeah,
yeah.
just between the pond and the road, we're gonna say.
I'm not interested in offering a condition that it has to go north around the pond or anything like that.
Right,
That's,
no.
I don't
No,
wanna
not
start
us.
dictating where someone would develop.
No,
Well, that's
Right.
So I think
that's
it's
the
more,
question I had, because if somebody else would own that and have different priorities
Yeah.
for that property, you wouldn't want to restrict that.
well, so then I'm gonna
To
ask
the
that question.
existing, so between the existing east and west entrance and ingress egress, south of the pond, north of the center line of the road, section line.
I mean, we can't
Well,
even begin
we're-
to speculate
Well,
what
when
future
because,
development
yeah,
will
when we
be.
talk to the, I guess I want to bring that up, when we talk about future development, we don't know what's gonna happen.
Right.
yeah.
When we mention the pond, a future development, that pond may not even exist.
Correct.
A new stormwater plan is done for a new development, you know.
Pond is expanded or whatever,
Yeah, or even
or
moved.
eliminated,
Yeah. So I guess that's another concern that I would
Go
have
back just to-
specifically mentioning.
Just the first.
Time certain to a triggering event of another
we
project
just go back to
requiring
that
site.
and approve.
This
Because-
one's gonna have a
because
few
that-
amendments to her.
Because
Make a
it,
motion.
because in that case,
That's true.
the new development, new sidewalk, and so we'd have the planning commission would delve into the specifics of
Yeah.
how can a sidewalk even be put in. So yeah, that's where I would just suggest that we don't want to, as your point, we don't know if the pond will even exist in the future.
Yeah, I just don't want to handcuff
Yeah.
anybody, you know, with that moving forward.
Just require a water hazard sign.
So,
So, Okay.
So we've gone through the variance, listing a potentially reasons A and C structure, the unique structure being that it was burnt down, a new structure needed due to the fire, applicant did not cause the fire, and so that is the condition, circumstance that did not result in the action of the applicant. And we've talked about the condition that the variance would only pertain to the existing accessory building shown in site plan amendment 2018-01. So we've talked about it. Is there, I guess, I think you started a motion, but we should probably start up with
Yeah,
a fresh
I haven't
new
started a motion. I'm
Okay.
still
No.
brainstorming.
Yeah, okay.
Right,
So-
we're just reviewing.
So then I think it's, in my opinion, I would like to see it based on for a duration to be determined, at which time a new project that requires a site plan approval and subsequently sidewalks be brought forward by the applicant. I don't know how to best word that, but
Variance up to a point of a next special use if it ever.
Another triggering.
Well, so
and it wouldn't have to be a special use either. That's the,
It would be
I mean, typically,
site plan review.
if you're looking for,
the next project that triggers the
Yeah.
site plan review.
yeah, if you're looking for language to borrow from the sidewalk 8.325, on the condition that any new construction or additions requiring site plan review per section 12 of this ordinance shall provide sidewalks in accordance with the Charter Township Union sidewalk ordinance.
As per, until 8.3 reapplies.
Right.
8.325 will take effect.
Because is that what you're getting at?
Yeah. The next project, right? The next
Yep.
permittable project that comes up that requires site plan review is going to negate this variance. The variance is good
Until then.
until that time.
Yep.
I think that's a very fair and reasonable approach to this because
Absolutely.
we're recognizing the special conditions, but we're not being, I was concerned about,
Removing from.
yeah, I was concerned about the variance being no sidewalks ever for, I mean, that doesn't
Right.
fit with the plan, the long-term plans and connectivity
That's
and
what-
sidewalks and pathways, so the special conditions based on this project, I think, are where I was kinda hanging my hat. Do we dare do a motion on that?
There should be a motion.
I need a motion.
You
So-
could have a
Or
new site
against.
plan because somebody wanted to pave 10 parking spots, actually. That would require.
Yeah,
That's new
it's not our,
construction.
yeah, it's not our purview to determine what that potential future development would be.
Right.
I'm only,
It'll follow the ordinance
Yeah.
within the township.
Okay.
So with that being said,
We would need a motion and a second, and
yeah. I need.
trying to write it down here to make sure I'm making sense here.
Okay.
Well, I think we kind of agree on what we want. I think we just need to wordsmith a proper motion that meets.
We just need a proper Twitter.
Are you working on one, Andy?
He is, I believe.
Let me give you my draft, Peter, and you tell me what I'm missing here. So the motion would be to offer a variance for installing sidewalks for site plan amendment 2018-01 for the accessory building in question, valid until the applicant's next project requiring site plan approval.
Yep, the only thing I do is conditioned on and use the word variance granted.
Okay.
And in there, did you give the reason on the variance?
Do you want me to
No.
cite all of those reasons, or
Well, yeah, 'cause
cite the special
well-
conditions?
well, and that's where I broke it down in A and E.
I think you-
A,
yeah.
you found a circumstance peculiar to the structure,
Mhm.
and
that it was not
and that
caused.
circumstance
Okay.
E was not, or C, excuse me, was
Yeah.
not caused by the actions of the applicant.
Yeah, I think we need to state how we arrived.
So that'd be the only things that I would add.
Because of a special condition.
Variance be granted
Yeah.
because A and C. The fire is peculiar to the structure, not the land.
All right, let's try it again. Make a motion for site plan amendment 2018-01 to grant a variance for installing sidewalks for the accessory building in question, based on the following conditions: that the variance is valid until the applicant's next project requiring site plan approval. Variance has been granted due to special conditions of a fire damaging the existing structure, and it is determined that the fire was not the direct result of the applicant's actions, therefore they meet the criteria.
Okay. Any support?
Support.
Any further comments? Hearing none? Okay. I'm sorry.
Just want to make sure we have the
But-
motion clear.
Okay.
The piece about a site plan, new construction by the applicant. I believe the variance follows the property, so I don't know if you want that word in there.
Valid point. Right. Yeah, because if the property were to change hands, we don't want it to negate the,
I think because you can borrow the words right from the ordinance on the condition that any new construction or additions
in 832.
in 8325. That the variance is only granted on the condition that any new construction or additions requiring site plan review per section 12 of this ordinance shall provide sidewalks in accordance. So,
Until the next.
yep, until that happens. That it's granted until new construction or additions requiring site plan review per section 12 of this ordinance. If that's, because that's not
Can I
being
make a friendly
specific to the,
amendment? Adding that language.
I accept that amendment.
Support it.
You got it, Jennifer?
I think that's.
Makes sense, okay.
I think we can do it that way.
So we have support. Your support with
Yep.
the amendments?
Absolutely. Support it.
Okay. Any other comments? Hearing none. Those in favor of the motion presented?
Aye.
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 Those opposed? Variance granted. Peter has a couple statements for you.
the decision of the board shall not be final until 21 days after it is made. And any person having an interest affected by any such ordinance shall have the right to appeal to the circuit court on questions of law and fact. Further, any person or persons or any taxpayer, department, board, or bureau of the township aggrieved by any decision of the Board of Appeals shall have the right to appeal in Isabella County Circuit Court on questions of law and fact. Keep in mind the 20-day countdown starts after the minutes are approved. Decision is not final until those minutes are approved. The minutes will not be approved until the next regularly scheduled meeting, at which point, once they're approved, the 21-day appeal begins.
Okay, thank you. Moving on. Other we have, new business. Section B, adopt the 2019 regular board meeting schedule.
So we've been doing this for, I believe, a couple years now. We changed from meeting quarterly to monthly. We've done it to assist in creating more opportunities for applicants to bring their business or concerns to the Zoning Board of Appeals without waiting 3 months to ask for variance if needed. It reduces the need for the additional cost on the applicant to pay for a special meeting. And it also has, I believe, reduced the number of items that we've seen on our agenda. When we had met quarterly before, there were times that we could be looking at 3-4 variances at a time. I believe in the past, meeting monthly, it's reduced to where we've only had maybe 1 or 2 items each meeting. And so you have a draft before you. If you're comfortable still meeting monthly, and those dates specified. If you have any conflicts with the specific dates, you want to bring them up. 2 that may, I don't know if anybody's going to have concern over, is one in January and one in July. We meet on the first Wednesday of the month, and the first Wednesday of January falls very close after New Year's Day. So I don't know if there's any considerations for that. And then also the July meeting, first Wednesday falls right before 4th of July. So, but if the board doesn't have any problems, we can keep those dates.
I always hesitate to try and adjust them because you never know what the application load might be, right?
Right. I mean, I guess, if anybody is gonna be gone, hopefully we got 2 alternates at this point, so we can be able to fill the board.
I most likely will be, but I think everybody else is pretty.
We'll take them each month as they come, if anybody else has any, otherwise.
Because I don't know where to even, where would you even shift it to make, people to
The
hit
other
that
township board
target?
meetings and everything, so.
You want a motion for that?
Yes, yes.
A motion to approve the suggested scheduled meetings for 2019 for the ZBA, first Wednesday of each month.
I'll support.
Support, John. Further discussion? All those in favor?
Aye.
Aye.
Opposed? Passed. 2019 schedule. Okay. Other business. Do we have other business?
Don't have any other business at this point.
Okay. At this time, I'll open it up to extended public comment. If anybody cares, has comments, step forward, state your name and address. Hearing none, close extended public comment. Any final board comment? Hearing none. This is ZBA meeting adjourned. 8:38.